as I mentioned, you have this jump in engine RPMs and a very dramatic jump in the reported speed of the vehicle. But when you look at the acceleration is actually dropping. So again, that's a telltale sign that the tire's spinning because the vehicle's not being accelerated. And so I've used the accelerometer data. Again, if you just, a process called integration, you integrate the accelerometer data, it will give you the velocity. So what I've done is, it's called piecewise integration to get the speed data that takes into account the tire slippage, and from there calculate the speeds or the position at each interval going across the top here.
If I could stop you at your column that says JBW speed at each time step.
Yep.
If you go to the bottom, please. So does your data indicate that the speed is changing at the end of this 10-second event?
Objection, Your Honor.
Sustained.
Is the speed changing at the end of this event?
Yes.
How so?
Well, again, you can see it's increased about 2.7 miles per hour. And again, we know from what I already stated that that last time step, you're still at 74% throttle and you have 0 brake application.
What did you think of Dr. Judson Welcher's testimony? We're recapping the best parts of it this morning. Let's bring in our guest commentators for some discussion now. Attorney Tommy Pope on the show with me this morning, and so is Attorney Randolph Rice. Good morning to you, gentlemen. Tommy, would you start us off, please? What do you think that Dr. Welcher did for the Commonwealth in terms of tipping the scales of justice?
I think if the jury's dialed in, it really takes their mind to the scene and kind of almost an inside view of what was occurring. That you know, even when he talks about the slippage, because you know the conditions, and I think it really brought him in. I would say if he's going to do his testing, he needs to either get a different T-shirt or wear a jumpsuit. He would have looked a little more professional to go with his PhD. But I thought he really brought the jury into the scene with the data that we heretofore, you know, hadn't had described in that way.
Right, Tommy. Randolph, your thoughts on Dr. Judson Welcher. Did you like him? Would you use him if you ever had a case where his expertise would come in handy?
Well, good morning, guys. You know, I did like him, actually, and I thought that this was a strong last witness for the Commonwealth because he really tied it all together, and as Tommy says, he visualizes this incident, this collision for the jury. It's hard to sort of think about how did, you know, John O'Keefe get hit? How could it have happened? And to put somebody up there and say, hey, look, this is what could have happened, and based on the data and science, this is what we think happened. I thought it was very effective.
Definitely. We've got more to show you both. Stand by kindly, please. We're going to hit a break. The clock continues ticking, and we've surpassed the 2-hour mark. We've surpassed it by about 9 minutes, almost 10 minutes. This is Court TV Live. We are your front row seat to justice. Right now, we turn back to Massachusetts and the retrial of defendant Karen Reed. We're in a verdict watch, a live look at the courtroom. We've got the fan spinning on the ceiling, and we've got the clock at 2 hours, 34 minutes and counting. Will we see a verdict? Last time, the jury stopped short of a verdict. They were hung, could not come to a decision on the charges. They've got 3 counts to consider: second-degree murder, manslaughter while under the influence of alcohol, and leaving the scene of an accident and personal injury. The top count carries life with the possibility of parole at 15, 20, or 25 years at the court's discretion. A lot at stake here for this defendant. Now, let's go back and listen to some more of the accident reconstructionist, Dr. Judson Welcher.
I would like to talk now about your paint exercise. You did not present, as you have stated, a force calculation with regard to the arm. You did a paint exercise, and what I want to do is to reference, and if we need to bring it up, sir, to refresh you, slides 103 to 120 of your PowerPoint presentation in this trial. I'll just call it the blue paint exercise. Is that descriptive enough for you to know what I'm talking about?
No, it's not an exercise, it's a test.
Okay, you want to call it a blue paint test?
Sure.
Okay, let's call it blue paint test. I just want to try to expedite things and use parlance that we can agree on.
Okey-doke.
So your blue paint test involved painting the right rear taillight blue, correct?
Correct?
Positioning the test subject behind the taillight, correct?
Correct?
With the arm held out, correct?
Correct?
And at a right angle, correct?
Correct?
And then the vehicle, the Lexus SUV, is backed into the test subject, correct?
So I ran 3 different tests.
I know, well, let's just do each one at a time, okay?
Okay, so you're starting with the last one.
I'll start with whatever one you want.
Okay, stepping aside from this for just a moment, and we want to kind of key in on the top count, because that's where the most at stake exists for defendant Karen Reed. Could be life in prison if she's convicted of that count. Let me bring in our legal analyst guests, Tommy Pope and Randolph Rice. I want to clear up, you both are aware of this, but I feel like it's just really worth a repeat in terms of what that charge says in the Commonwealth of Massachusetts. And the subsection they've alleged here doesn't require any intent to kill another person. Karen Reed did not have to intend to kill John O'Keefe. The allegation is just that she intended to do an act which a reasonable person would know consisted of a strong likelihood that death could result. Do you both think that the Commonwealth has proven the case when it comes to that charge? Randolph, I'll begin with you, please.
No, not at all. I really don't think that they've got the intent, that she knew that she was causing an act that you, again, I think the more important part of this, that you know would actually cause, reasonably know to cause the death. And the point is that I don't think that they got to the point of proving that she knew that she was backing into John O'Keefe. And that's the problem. You know, the knowledge, the expert, Dr. Welcher can get up there all day long and talk about paint transfer, but not getting in the mind of Karen Reed, that's the problem.
I appreciate it, Randolph. Tommy Pope, your thoughts. Have they proven count 1?
I think they, I was thinking about intent, and I think because she was intoxicated, she might not have been able to develop intent. And I understand what you're saying the law says. And so I think there's almost an additional layer of how voluntary intoxication plays in. In South Carolina, that's not a defense. And so knew or should have known. And I think they prove she's reckless. Now, again, I will recognize to the point of taking a life, but, it's equivalent to our recklessness here, but it's got a lot heavier penalty than we would see in a involuntary manslaughter, for example.
And we've got count 2, manslaughter while under the influence of alcohol, and count 3, leaving the scene of personal injury. So 3 counts for this jury to consider. Tommy Pope, Randolph Rice, thank you both so much for weighing in for the great legal analysis this morning. We'll see you soon. We're going to hit that